Good morning and welcome to the Court of Appeals. Appreciate y'all being here today. I know perhaps it's not necessarily where you would want to be if you could choose, but anyway, we do appreciate that. I know we've got experienced practitioners in front of us, but I want to feel the necessity to touch on at least a few things before we get started. First of all, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your oral argument. The lighting on the podium is what we believe to be very straightforward. Of course, we've seen it a bunch of times. So as long as the light's green, you've got plenty of time. Once the light turns yellow, you're running out of time, and once the light turns red, you are out of time, and we ask that you please respect those time constraints as well. Your panel for this morning consists of Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. One more thing I need to touch on, just to make everybody aware, is these arguments are being live streamed. So once you get up and begin your argument, be mindful of what you say, because once you say it, it's out there for everybody to see and everybody to hear. So we just ask that you be mindful of that. Miss Angie, anything before we take up the first case?
No, Your Honor.
You may call the first case, please.
Christina Lewis et al. Versus Walter Fletcher et al.
Good morning, Your Honors.
Good morning.
Chuck Holliday for the appellant. I would ask for 4 minutes for rebuttal, please.
4 minutes. You may proceed, sir.
May it please the court. This court should reverse the trial court's decision granting summary judgment because Tennessee recognizes claims for negligence per se in cases like this. And the trial court properly found that the facts in this case presented issues of fact that prevented summary judgment on the affirmative defense of comparative fault. Standing here, I can't help but feel a bit stunned like Jets fans after Monday Night Football. The Jets thought they had this season wrapped up with the addition of a Hall of Fame quarterback to their roster on their offense. A few plays into the game, however, Aaron Rodgers was tackled on what appeared to be a routine play. Turns out he tore his Achilles and is out for the rest of the season. This case seemed pretty straightforward, routine, if you will. Miss Lewis fell off some stairs that were wide enough they invited two people to walk down them. So wide that for decades the building codes had required that stairs that wide be required to have two handrails. She sued and alleged common law fault and negligence per se. The evidence shows that when the building was built in 1993, it was built with only one handrail. So the defendants have been on constructive notice of this condition for more than 2 decades before her injury. The defendants...
I'm curious about that. When you say they've been on notice, are they presumed to know when they buy the building, or did they have notice that there was some type violation? Is there any information in the record about that?
There's no information in the record that they had actual notice, but a property owner is generally held to be on constructive notice of the status of their property. There's that old saying, Your Honor, that ignorance of the law is no excuse, and if the building codes required that a building be built to a certain standard at the time it was built, like it or not, the law holds that that person is responsible for those conditions, and they're on constructive notice at that point.
Well, they didn't build the building, though, did they?
They did not, Your Honor.
Okay, they bought it subsequent to that, and I'm just curious if there's anything in the record about when they got notice that this was not in conformity with what the law required.
The only thing that I know of, Your Honor, as to when they got notice that it was not in conformity with the law was probably the filing of the lawsuit. It's the best I don't believe there's anything in the record as to any notice beforehand from any code inspector or city authority or anything of that nature.
Okay.
Let me ask you, I'm curious about that as well. I assume the building was, there was a use and occupancy when the building was built, and it went through the building codes here in Jackson?
It's in Weakley County.
Oh, excuse me, Weakley County. What is the expectation when someone buys the building? Are you suggesting that they have to have an engineer go through the building and determine whether or not the building's up to code at the time it was built? Is that common in real estate?
Your Honor, in this case, the facts show that and of course, the partnership that's been sued in this case bought the building subsequent to the initial partnership that had it constructed. They were two separate entities technically because doctors changed practices and moved in and out of there.
And there's no proof that at the time that it was built, that there was any issue with, as far as the building department, or that they violated building codes at the time it was built, or did anything to, outside illegally at the time it was built. There's none of that is there?
Your Honor, there's absolute evidence that at the time it was construction and the time they took possession of it, it did not comply with the codes in effect at that time. That's in the record, that the state of Tennessee had adopted the 1988 Standard Building Code, which provided that a stairway 44 inches or greater must have 2 railings on each side.
And who enforced that at the time the building was built?
The state fire marshal. The defendants point out that there were no regulations in the city of Martin. There were no building regulations. That's not fatal to the case. All that does is prove that in the absence of a local government to adopt standards, the state standards apply. There's a case that we cite in our brief about where the court talked about that in another instance. The state fire marshal was given authority by the legislature to set these types of standards and to adopt them. And by statute, the state fire marshal has adopted the codes and regulations, including the 1988 Standard Building Code.
I guess my question is, how is that enforced at the local level when someone builds a building? I mean, in other words, how did this fall through the cracks, if you will, such that it would require someone who purchases the building to do a follow-up to determine whether or not what the person who built the building did was illegal?
Your Honor, I don't know there's nothing in the record as to what exists when someone takes over a property to make sure that it complies with the law. We didn't get to the point, there was no deposition of a codes inspector taken. I mean, we concede that the defendants point out that it passed a code inspection, but those code inspections don't always necessarily state that everything under the code meets code. That's not necessarily when the building inspectors go in, they don't check the entire code. There's nothing in the record about that. But once the property owner takes possession of the property, the codes are the codes, and the ignorance of the law because a building inspector missed it or because the contractor didn't build it to specifications, the law exists there, and ignorance of the law is not an excuse.
Well, let me try it a different way. Normally, and I assume that this happened in this situation, when a building's built, there's a certificate of occupancy that is granted by whoever that governing authority is, whether it be the fire marshal or the city, or I assume that was done here, or is there anything in the record about any of that?
There's nothing in the record to contradict that a certificate of occupancy was issued. I think, in fact, Mr. McClain may be able to point specifically to that. I think they suggested there was one that was submitted.
Okay. So at that point in time, that I assume means you're good to go. Everything's finished.
I think, Your Honor, that's the incorrect assumption, is that by getting a sign-off from a city official, this building has met all of the codes at the time. I don't believe that the record establishes that once a city official signs off, they are certifying that every code in effect at the time has been complied with.
Well, then, harken back to what Judge Golden asked you. Where does it end? you've got a builder who has built a building, and we're talking theoretically here, I said, because I don't guess there's anything in the record about it, but you got a builder who's built a building. Everybody who's supposed to look at it has waved their hand over it and said, you're good to go, move in. But what you're suggesting is he's never good to go, that there's this specter always hanging over his head, is that the people who were supposed to say, but there's a problem here, or this doesn't meet code, is hanging out there forever.
Your Honor, and that's true in every aspect of life. If you go and take your car and have work done and have your windows tinted or some alteration done to your car, and somebody tells you, a city inspector says you're good to go, this passes inspection, and then you go out on the road and a police officer pulls you over and says this violates this section of the code, the fact that that person told you that you were good to go or that city official signed off on that doesn't absolve you of liability. At the end of the day, the question is whether it violates the code or not. I will concede and admit that it appears there is some manner of this that is somewhat seems unfair, that they built it, they hired this company to come in to do this, it signed, the city signed off on it, and then 20 years later they're told it's not up to code. That may go to what a jury ultimately finds in this case as to how much fault they have under the comparative fault analysis. But to suggest that they are not liable for negligence per se in this case is not consistent with the law and this court's decisions on that issue, including Smith v. Owen.
You keep saying the city inspector in your references, but yet I think it's undisputed here that there were no local codes for the city of Martin, Tennessee. So if I'm following your argument, you're saying that the codes that were violated here were codes of the state of Tennessee and the state fire marshal. And so I'm curious about when you keep referencing the city inspector, well, what was the city inspector supposed to be doing? If there were no city codes, then what was the point of a city inspector and whether he or she approved or didn't approve?
And Your Honor, I don't believe we have in the record, but I think I agree with your point that in this case, because the city did not have any building codes, we don't have in the record the scope of the city inspector. Is the city inspector required to inspect for all of the statewide codes, including the Southern Building Code that was in effect at the time through the state fire marshal? That's simply not in the record as to the scope of the building inspector's duties. But I would go back to the point that regardless of what the inspector was required to do when he or she inspected that property and signed off on it, that once the property owner took occupancy, they were required to comply with the law whether they had had it signed off or not. That does not absolve them of the obligation to comply with the laws in effect at the time.
But that's not who you're suing. You're not suing the people that built the building, apparently improperly. You're suing people that bought it from the people who built the building. And the question is, how far does that liability extend? And what responsibility did they have when they purchased the building? What's in other words, I guess you're maybe talking about what's common in the industry. I mean, what is required? This isn't like a property search or to determine whether there are any liens on the property and whatnot. I mean, are we saying that if we decide this case in your favor, that from now on everybody that purchases a building is going to have an engineer go through it and make sure that every state building code has been complied with when the building was built? Is that what you're suggesting?
Yes, Your Honor, because I believe that's what the law already requires.
Is that right? What do you cite to for that?
Your Honor, I would cite to this court's previous decisions. Look at the Dowdy case that this court had regarding negligence per se of smoke detectors. If someone had signed off on that and those people were allowed to move in without smoke detectors and those children died, and the trial court found negligence per se, and the defendants came in and said, well, we bought this from the other entity and it was signed off by them, I believe this court's jurisprudence suggests that that would not be a basis for not imposing liability. Again, it may go to the comparative fault issue, but as to the issue of negligence per se, I don't believe it would absolve them of liability.
All right,
Thank you.
You've got your rebuttal time.
Morning, Your Honors. Albert McLean for the defendants, the appellees. In response to Your Honor's questions previously to Appellant's Counsel, in the record, there is an undisputed fact in the motion for summary judgment, which is found in the record in volume 3, page 233, which is item number 29, which states, the building in question on the property was completed in 1993 and passed inspection by the City of Martin prior to Carroll's occupancy of the building, and the response was undisputed. So that's an undisputed fact. As far as the enforcement of the regulations under the Tennessee Rules and Regulations, Regulation 0780-02-18-.04. This is not cited in the record, but it is a matter of public record. It states, the responsible authority for the enforcement of these regulations shall be the local building inspector and the State Building Commission with respect to state public buildings as provided in TCA 4-15-106A, and B, the State Fire Marshal with respect to public buildings reviewed under the authority of TCA 68-120-101D. So I would submit that the local building inspector...
Excuse me just a second.
Yes.
Is that in the record?
This is not in the record, but it's a matter of public records.
What we need for you to do then is, after argument, if you will, send a letter as supplemental authority if you want the court to rely upon that. And
very-
obviously give Mr. Holliday an opportunity to respond to it.
Oh, right, sir. Thank you, sir.
Thank
With regard to my prepared remarks, Your Honor, I would just submit that the common law rule of landlord non-liability, which is the basis on which we moved for summary judgment and on which the trial court granted summary judgment, has been the law in Tennessee for over 100 years. In the case of Wilcox versus Hines, 46 Southwest 297, an 1898 decision by the Tennessee Supreme Court, it was stated that a landlord is not liable to a tenant on the grounds of negligence for an injury resulting from an unsafe or dangerous condition on leased premises that was in existence as of the date of the lease, if, as of the date of the accident, the tenant had knowledge of the condition. And that rule has been restated in subsequent cases in Maxwell versus Daveco Corporation, 776 Southwest 2nd, 528, Tennessee Court of Appeals decision 1989, permap denied. And then more recently in Lethco versus Holden, which is the case that we relied on primarily in the trial court, which is 31 Southwest 3rd, 254, Tennessee Court of Appeals decision 2000, permap denied. In Lethco, this court stated a rule as follows, quote, when a landlord and a tenant have coextensive knowledge of the dangerous condition, the landlord is not liable to the tenant or the tenant's employees for injuries sustained as a result of the dangerous condition, close quote. And that's at page 256. And exceptions to this general rule have been recognized by the Tennessee Supreme Court over the years, including one in which the dangerous condition was caused by the landlord's failure to make repairs that it had a duty to make under the contract, which in this case we say there is no duty under the contract. Number two, a dangerous condition exists over portions of the property over which the landlord retained control, and we submit that the entire premises was leased to the tenant and that they had responsibility over the entire building and land on which it sat.
Do we know how long had that tenant been in possession of the property, and how long had that employee been working in the building?
The tenant had been in possession of the property since the original construction. Carroll took possession in 1993 and remained in possession through the years after, through the date of this accident in 2014. The employee had worked for Carroll for, I believe, 6 years. The record shows that she worked at that place for 6 years, and she walked in and out of the building at the address where the accident happened on a regular basis every day. In the record, it shows she did that every day. So she was very well familiar with the steps and the condition of the steps and the fact that there was one handrail on one side and not one on the other side. Then we would submit, Your Honor, that based on this law, that the plaintiff, Ms. Lewis, is not entitled to recover against the owner, our clients, on negligence, and that includes negligence per se. Negligence per se is just another form of negligence. Ms. Lewis has asserted in the trial court that she has a claim for negligence per se based on, in the trial court, it was based on the alleged violation of a building code section. And although that building code section was not pled in the complaint, it was included in response to a motion for summary judgment that we filed. And in the trial court, in the oral argument before the trial court, Ms. Lewis' counsel argued that the violation of that building code was the basis on which they asserted a negligence per se claim. No violation of a statute was alleged, no violation of an ordinance was alleged, just the violation of this building code section. And we submit in the trial court and submit to this court that in and of itself, the violation of building code, unless the building code imposes some duty on the subsequent owner, which it did not, then there is no basis for negligence per se, merely based on that building code, because that building code is a construction code. It's what guides builders who build buildings and people who have buildings built for them. In and of itself, the violation of a building code is not, I would submit, is not negligence per se. Then subsequently, after the case was decided by the trial court and has come up on appeal, Ms. Lewis has asserted that there is a statute that applies, which was never pled, never mentioned, never asserted in the trial court, which is in the record, and basically it states that that it is unlawful for a building to be in violation of the building code. It states it is unlawful to, quote, maintain, occupy, or use a building or part of any building or structure that has been erected or altered in violation of any rule promulgated as provided in this chapter. That's a quote. We would submit that even if that statute were properly pled and relied on in the trial court, which it was not, it would not apply to the owner because it would apply to the tenant, because the tenant, quote, maintained, occupied, and used, close quote, the building in question based on the lease agreement. Also significant, we submit, without waiving any of our rights to argument, that there was no statute pled in the trial court on which the negligence per se claim was based. Another statute in this series of statutes that Ms. Lewis has alleged for the first time in a reply brief in this court, a statute in the same chapter is TCA 68-20-108, which provides that an owner of a building that has a construction defect is only subject to a fine if, quote, anything in willful violation of this chapter has been constructed or exists, close quote. And the record is clear that there was no willful violation of any building codes. The record is clear that there was never any notice given to our clients, the owner of the building, of any violation of any building code. And again, as we stated earlier, the local building inspector had approved the construction of the building. So there clearly was no willful violation of any building code section.
How did these statutes, and I understand you're asserting they were never asserted in the trial court, so the trial court nor you ever got a real chance to reply to them, but realizing that they're out there, and just to make sure we understand your argument.
Right.
Do these statutes change the general rule that Judge Susano promulgated in Lethco. How does that impact that, or does it impact that?
We would submit it does not change the rule that the general rule of landlord non-liability applies even in the case of a statutory violation. And we cited a case that this court issued an opinion on, which is Richardson. Let's see if I get the cite. It's cited in the record. In which this court held that despite the fact that there was alleged a statutory violation under the Uniform Residential Landlord and Tenant Act, which was the basis on which the plaintiff asserted a claim against the owner, the landlord, the trial court granted summary judgment to the owner, and this court affirmed the summary judgment and held that the violation of that statute did not displace, or excuse me, that the statute on which the plaintiff was asserting a violation did not displace the common law defense of landlord non-liability because the statute did not state that it replaced. In other words, it didn't indicate in the statute that it was replacing the landlord rule of non-liability. I would submit the same thing is true in this case. Whether you look at the regulation that the plaintiff cited in the trial court, or whether you look at any of these statutes that the plaintiff has subsequently brought before the court in the record, which was not pled in the trial court, in those statutes, they do not purport to displace the common law rule of landlord non-liability. Those statutes do not say in there anything like it shall be unlawful to lease a building that's in violation of this to any person. Or it does not use that type of language. So there's no indication that it's intending to displace the common law rule of landlord non-liability. So that would be our position if your honors got to the point of looking at that as a basis for any kind of relief on the part of Ms. Lewis. But we would submit that there is no basis for Ms. Lewis to now assert that statute because it was not pled in the trial court, not mentioned in the trial court, and it was waived by the fact that it was not mentioned or pled in the trial court. And the courts, this court and other courts have held that an issue not raised in the trial court cannot be a basis for relief in the appellate court. So we would submit that for all those reasons, the trial court was correct in ruling the way it did. And then as alternatively, we have also raised the issue of the comparative fault of the plaintiff in the event your honors found that the trial court was in error in granting summary judgment on the grounds of landlord non-liability. We would submit that there's an equally valid basis on which summary judgment should have been granted, which the trial court did not grant, which is that Mrs. Lewis's fault was at least 50% as a matter of law, and we have cited in our briefs several cases in the Court of Appeals in which the Court of Appeals, in reliance on Perez versus McConkey, has stated that in a case in which a person is injured in a slip and fall situation, which is an open, obvious type situation, that the courts look to, one, whether or not the plaintiff was aware of the condition, number two, whether or not the plaintiff voluntarily encountered that risk, and number three, whether or not the plaintiff could have avoided that risk. And in this case, we have all three of those factors. The plaintiff was well aware of the risk, walking down the steps with no rail. She encountered that risk voluntarily. She didn't have to walk down the side of the steps with no rail. She could have walked down the steps with a rail, but she chose not to. So we would submit that if the court were to find that the trial court was in error in granting summary judgment for landlord non-liability, that this court should find that the plaintiff is barred from her claim because of comparative fault based on these cases that I just mentioned and cited in the record. And I think that covers everything I have to say.
All right, sir. Thank you very much.
Thank you very much.
I believe you have 4 minutes, Mr. Holliday.
Thank you, Your Honor. Judge Golden, to go back to the discussion we were having at the end of my initial argument, Section TCA 68-120-102, which is cited on page 9 of the reply, does discuss that the state law says that maintaining, occupying, or using a building that's been erected or altered in violation of any rule promulgated, provided in that chapter is a violation. It is black letter law in this case.
Did you say in your reply brief?
Yes, Your Honor. That's the statute that we cite in the reply brief.
Okay, let's talk about opposing counsel's statement that you did not cite this statute or what you're relying upon now for the negligence per se.
Certainly, Your Honor.
Is that accurate?
No, Your Honor. Tennessee is a notice jurisdiction. We simply use the pleadings to provide notice of the claim. The plaintiff told the defendants exactly what they did wrong. The plaintiff said, look, you were required to comply with these codes, and not only did you not comply with them, this stairway was required to have railings on both sides, and you didn't do that. Had the opposite occurred, had the plaintiff simply cited a section of TCA 120-102 and come into court and said, we've sued you for negligence per se under this statute, the defendant would be here today arguing, they didn't tell us what we did wrong. They didn't give us notice. That statute is simply the nexus.
Let me ask you a question, a very direct question. Did you cite this statute to the trial court?
No, Your Honor.
Okay. What does that do to your argument here?
Well, first, Your Honor, the defendants waived that argument in the trial court because it was never raised or argued except in one spot in their brief. There was no discussion of the failure to raise a statute. If you review the record, there's no argument about that.
Okay. How did the defendants waive it if you never raised it?
The defendants cite 805, I think it is, Your Honor, about citing a regulation in a statute in a pleading. That's an affirmative defense they're required to state in their answer. They never raised that in their answer. They never raised it in this court. They don't even raise it as an issue in their brief. It's simply cited at one page in the statement of the facts, I believe. They bring it up in a roundabout way to suggest that that statute was not cited. That boat has long since sailed and was not brought up initially when they filed their answer, nor when they argued to the trial court. There was one small statement in their brief, and as we note in our brief and cite to the record, there was no argument developed that we had failed to cite this statute that was necessary. And that statute is just the nexus between what we put them on notice that we said they did wrong, which was to violate a specific building code. We told them, we gave notice, this is what you did, and that statute is the nexus between that and the negligence per se argument. Your Honor, if this court were to hold that Lethco abrogates and provides that negligence per se actions are not available in this context, it would be abrogating the legislative prerogative. The legislature enacted all of these rules and regulations and told the state fire marshal, you apply these, and the failure to apply these in case after case after case. Negligence per se, the Smith case itself is the violation. It just happens to be a city code as opposed to the state fire marshal code. There's no difference between those in the effect that they have and the liability it imposes. For those reasons that we would ask that the court reverse summary judgment in this case. We've cited and argued in our case why comparative fault is not proper for summary judgment, and ask that it be sent back so that a trier of fact can look at this case and decide it. Thank you.
Thank you. Thank you, counsel. We appreciate your arguments, the briefs you filed. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused.